Hello everyone. Today we are going to discuss pleading, its rules and amendments under the law subject pleading and drafting, right? So let us start with the topic, which is pleading, its rules and amendments. So in this we are going to understand the meaning of pleading, what are the fundamentals, what are the principles, and how the pleading is drafted, right? And pleading includes uh, this plaint and written statement, right? So let us start with the topic. It is pleadings, its rules and amendments, right? So pleadings are the backbone of legal profession. It is the foundation stone on which case of a party stands, right? The case of a party must be set out in the pleadings. Moreover, a relief cannot be claimed on the grounds which are not contained in the pleadings. The immaterial or vague or ambiguous matters should be avoided, and pleadings should be properly framed, right? In Devki Nandan versus Murlidhar, it was held that a finding cannot be sustained which is based on no pleading and no evidence, right? Pleadings are those materials or essential facts which are necessary to be averred in order to put forward a cause or to establish a defense in a judicial proceeding. It is the backbone of the suit upon which the entire edifice of the suit rests. It includes allegations and counter allegations made by one party and denied by the other. Etymologically, it means a formal statement to propound the cause of action or set up a defense against the case of the plaintiff. According to Moga, pleadings are statements in writing drawn up and filed by each party to a case, stating what his contentions will be at the trial and giving all such details as his opponents needs to know in order to prepare his case in answer, right? Order 6 of the Code of Civil Procedure deals with the pleadings in general. Rule 1 defines pleading, while Rule 2 lays down the fundamental principles of pleadings. Rule 3 to 3 to 13 require the parties to supply necessary particulars. Rule 14 and 15 provide for signing and verification of pleadings. Rule 16 empowers a court to strike out unnecessary pleadings, right? Rule 17 and 18 contain provisions relating to amendment of pleadings, right? As per Rule 1 of Order 6 of Code of Civil Procedure, pleading is defined as plaint or written statement. It is important to know here the meaning of plaint and written statement. Plaint is the statement of plaintiff containing grievances in order to initiate an action in a court of law. It helps the court to determine the real nature of the suit. Written statement is the statement or defense of the defendant by which he either admits the claim of the plaintiff or denies the allegation or averments made by the plaintiff in his plaint, right? Objects and importance of pleading, right? In the leading case of Thorpe versus Holdsworth, Justice M.R. stated, the whole object of pleading is to bring parties to an issue, and the meaning of rules relating to pleading was to prevent the issue being enlarged, which would prevent either party from knowing when the cause came on for trial, what the real point to be discussed and decided was. In fact, the whole meaning of the system is to narrow the parties to definite issues and thereby to diminish expenses and delay, especially as regards the amount of testimony required on either side at the hearing. The object of pleadings are to bring the parties to definite issues, to prevent surprise and miscarriage of justice, to avoid unnecessary expense and trouble, to save public time, to eradicate irrelevancy, and to assist the court, right? Importance of pleading cannot be underestimated. Jacob states, pleading do not only define the issue between the parties for the final decision of the court at the trial, they manifest and exert their importance throughout the whole process of the litigation. Pleadings provide a guide for the proper mode of trial. They demonstrate upon which party the burden of proof lies and who has the right to open the case. They also determine the range of admissible evidence which the party should adduce at the trial. They also lay down limit on relief that can be granted by the court. So let us have a look at the rules of pleadings. These are, for the purpose of understanding of rules of pleading, it may be divided into two heads: fundamental or basic rules, particular or other rules. Right? Fundamental or basic rules of pleadings. Subrule 1 of Rule 2 of Order 6 of the Code of Civil Procedure lays down the fundamental principles of pleading. It reads as under: every pleading shall contain only a statement in a concise form of the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved. Right? From the above provision, it can be said that following are the fundamental or basic rule of pleading. Pleading should state fact and not law. The fact stated in pleading should be material facts. The pleading should not state the evidence. The facts in pleading should be stated in a concise form. Now, these rules are discussed in detail one by one. So, we are going to discuss in detail. Pleading should state facts and not law. It is the first fundamental rule of pleading. It says that pleading should state only facts and not law. In the case of Kedar Lal versus Hari Lal, it was held that it is the duty of the parties to state only the facts on which they rely upon their claims. It is for the court to apply the law to the facts pleaded. In case of Gauri Dutt Ganesh Lal firm versus Madhav Prasad, it was held that the law of pleading may be tersely summarized in 4 words: plead facts, not law. In Ram Prasad versus State of MP, it was held that a mixed question of law and fact, however, should be specifically pleaded. Again, in Union of India versus Sitaram Jaiswal, the court held that a point of law which is required to be substantiated by facts should be pleaded with necessary facts. Right? The facts stated in pleading should be material facts. Right? It is the second fundamental rule of pleading. It says that pleading should contain a statement of material facts and material facts only. Here, one most important question is, what is the meaning of term material facts? The term has not been defined in the Code of Civil Procedure, but the court defined this term in many judicial pronouncements. Like in the case of Union of India versus Sitaram, the court said that material facts means all facts upon which the plaintiff cause of action or the defense depends, or in other words, all those facts which must be proved in order to establish the plaintiff's right to relief claimed in the plaint or the defendant's defense in written statement. Again, in the case of Uddhav Singh versus Madhav Rao Scindia, the Supreme Court said that the term material fact means all the primary facts which must be proved at the trial by a party to establish the existence of a cause of action or its defense are material facts. Right? So now I would like to mention an important thing, that I have got all these content from Google and from the respective blogs available on Google. Right? I would like to make it very clear that I have got no copyright on this on the content. I repeat, I have got no copyright over this content. I have got all this information from the Google and from the respective blogs available on the Google, right? So all this content has been taken from there. I repeat, I have got no copyright over the content. I repeat, I have got no copyright over the content in the video. Let's move further. Again, in Virender Nath versus Satpal Singh, the Supreme Court held that the phrase material facts may be said to be those facts upon which a party relies for his claim or defense. In other words, material facts are the facts upon which the plaintiff cause of action or the defendant's defense depends. What particulars could be said to be material facts would depend upon the facts of each case, and no rule of universal application can be laid down. It is, however, absolutely essential that all basic and primary facts which must be proved at the trial by the party to establish the existence of a cause of action or defense are material facts and must be stated in the pleading by as the party. In the same case, the Supreme Court also said a distinction between material facts and particulars, however, must not be overlooked. Material facts are primary or basic facts which must be pleaded by the plaintiff or by defendant in support of the case set up by him, right? Either to prove his cause of action or defense. Particulars, on the other hand, are details in support of material facts pleaded by the party. They amply refine and embellish material facts by giving distinctive touch to the basic contours of a picture already drawn so as to make it full, more clear and more informative. Particulars thus ensure conduct of fair trial and would not take the opposite party by surprise. The Supreme Court further said that whether a particular fact is or is not a material fact which is required to pleaded by a party depends on the facts and circumstances of each case. Let's move further. Pleading should not state the evidence. This is the most important rule. It is third fundamental rule of pleading. It says that pleading should contain a statement of material facts on which the party relies, but not the evidence by which those facts are to be proved. The facts are two types: facta probenda, the facts required to be proved, material facts; facta probentia, the facts by means of which they are to be proved. Right? Facta probentia means the facts by which facta probentia means the facts by means of which they are to be proved. Particulars or evidence, right? The pleadings should contain only facta probenda and not the facta probentia. The material facts on which the plaintiff relies for his claim or the defendant relies for his defense are called facta probenda, and they must be stated in the plaint or in the written statement, as the case may be. But the facts or evidence by means of which the material facts are to be proved are called facta probentia and need not be stated in the pleading. The facts in pleading should be stated in a concise form. Right? This is another important rule. It is fourth and last fundamental rule of pleading. It says that the statement in pleading should be stated in a concise and in brief form. In Virendra Kashinath versus Vinayak and Joshi, the words in concise form are definitely suggestive of the fact that brevity should be adhered to while drafting pleadings. Of course, brevity should not be at the cost of excluding necessary facts, but it does not mean niggling in the pleading, right? But it does not mean niggling in the pleadings. It is if care is taken in syntactics process, right? It says if care is taken in syntactic process, pleading can be saved from tautology. Particulars or other rules of pleadings. So let us have a look at it. Besides the fundamental or basic rule of pleadings, there are other or particular rules of pleading which are as follows. Whenever misrepresentation, fraud, breach of trust, willful default or undue influence are pleaded in pleading, particulars with dates and items should be stated. The performance of condition precedent need not be pleaded, since it is implied in the pleading. Non-performance of condition precedent, however, must be specifically and expressly pleaded. Generally, departure from pleading is not permissible, and except by way of amendment, no party can raise any ground of claim or contain any allegation of fact inconsistent with his previous pleading. A bare denial of a contract by opposite party will be construed only as a denial of factum of a contract and not the legality, validity or enforceability of such contract. Documents need not be set out at length in the pleading unless the word there are material. Whenever it says wherever malice, fraudulent intention, knowledge or other condition of mind of a person is material, it may be alleged in the pleading only as a fact without setting out the circumstances from which it is to be inferred. Such circumstances really constitute evidence in proof of material facts. Whenever It says whenever giving of notice to any person is necessary or a condition precedent, pleading should only state regarding giving of such notice, without setting out the form or precise term of such notice or the circumstances from which it is to be inferred, unless they are material. Implied contract or relations between persons may be alleged as a fact, and the series of letters, conversations, and circumstances from which they are to be inferred should be pleaded generally, right? Facts which the law presumes in favor of a party, or as to which the burden of proof lies upon the other side, need not be pleaded, right? Every pleading should be signed by the party or one of the parties or by his pleader. A party to the suit should supply his address. He should also supply address of the opposite party, right? Every pleading should be verified on affidavit by the party or by one of the party or by person acquainted with the facts of the case, right? A court may order striking out a pleading if it is unnecessary, scandalous, frivolous, vexatious, or tends to prejudice, embarrass, or delay fair trial of the suit, right? A court may allow amendment of pleadings, right? Forms in Appendix A of the Code should be used wherever they are applicable. Where they are not applicable, form of like nature should be used, right? Every pleading should be divided into paragraphs, numbered consecutively. It says numbered consecutively. Each allegation or averment, it says each allegation or averment should be stated in a separate paragraph. Dates, total and totals and numbers should be written in figures as well as in words, right? To avoid any confusion. Amendment of pleading. Amendment is the formal revision or addition or alteration or modification of the pleading. Provision of the amendment of pleading are intended for promoting the ends of justice and for defeating them. Rules 17 and 18 of the Order 6 of the Code of Civil Procedure 1908 deals with provision regarding amendment of pleadings and failure to amend after order respectively, right? Rule 17 of the Code of Civil Procedure 1908 provides that the court may at any stage of the proceeding allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties. Proviso to Rule 17 of Order 6 of the Code of Civil Procedure 1908 as inserted by the Code of Civil Procedure Act 2002 restricts and curtails power of the court to allow amendment in pleading by enacting that no application for amendment should be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence the party could not have raised the matter before the commencement of trial, right? Amendment of pleading when granted. It says when amendment of pleading is granted, right? Amendment of pleading when granted. Amendment of pleading can be granted by the court in two situations. Let us see. When the amendment is necessary for the determination of real question in controversy, can the amendment be allowed without injustice to the other side, right? After this, it is amendment of pleading when refused. So, at what point of time when an amendment of pleading can be refused, right? So it says amendment of pleading when refused. Amendment of pleadings can be refused in many circumstances. Following are the situations or circumstances when amendment of pleading can be refused by the court. It is when the proposed amendment is unnecessary, when the proposed amendment cause an injury to the opposite party which cannot be compensated for by cost, right? When the proposed amendment changes the nature of the case, when the application for amendment is not made in good faith, when there has been an excessive delay in filing the amendment application, right? So all the videos have been made for educational purposes only, right? I repeat, I've got the content from the Google and from the respective blogs available on the Google, right? I have got no claim I've got no copyright over all the contents. I repeat, I have got no copyright over all the contents available here, right? The video has been made for the educational purpose and for the information and for the just to provide information, right, about the particular topic, right? Just to provide information, just to educate people about the topic, right? It is an educational video, right? I have got no copyright. I repeat, I have got no copyright over the content in the video. Let's move further. Failure to amend. Rule 18 of Order 6 of the Code of Civil Procedure 1908 deals with this issue. It provides that if a party who has obtained an order for leave to amend does not amend accordingly within the time limit for that purpose by the order, or if no time is thereby limited, then within 14 days from the date of the order, he shall not be permitted to amend after the expiration of such limited time as aforesaid, or of such 14 days, right? As the case may be, unless the time is extended by the court, right? So I repeat, I have got no copyright over the content. I have got no copyright over the content. Let's move further. Here it is the conclusion. Let us come to the conclusion. So whatever things we have discussed so far, so here in nutshell, right? So all the crux is we are going to deal with the crux, right? So it is going to be a quick revision of whatever things we have gone so far in this particular video, right? So whatever things we have discussed so far. So let us see. Pleadings are the backbone of legal profession, right? It says as the pleadings are the backbone of the legal profession. It is the foundation stone on which case of a party stand, right? It is the foundation stone, right? So pleadings state everything about the cause of action. Everything is stated. If the case is supposed to be filed from, if the plaintiff is filing the case, so he will file the plaint, right? And in order to respond, whatever allegations, whatever things have been written in the plaint, so that will be answered by defendant with the help of written statement, right? So the plaintiff files, whenever he files complaint, whenever he files a case, whenever he files a suit, right, in the civil court, so that will be filed with plaint only, right? And whenever whenever the plaint which is filed by the plaintiff is going to be answered, so that will be answered by defendant with the help of written statement, right? So plaintiff files the plaint and a defendant files the written statement, right? So pleadings are the backbone of the legal profession. It is the foundation stone on which case of a party stands. The case of a party must be set out in the pleadings. Pleadings do not only define the issue between the parties for the final decision of the court at the trial, they manifest and exert their importance throughout the whole process of the litigation, right? Pleading provide a guide for the proper model of trial. They demonstrate upon which the party the burden of proof lies and who has the right to open the case, right? They also determine the range of admissible evidence which the party should adduce at the trial. They also lay down limits on the relief that can be granted by the court, right? So as I said, all the videos which are made by me, all those videos have been made with the help of content available on the Google, right? And content available on Google on the respective blogs. So I repeat, I've got whatever videos I have made with the help of all the content available on the Google, right? Google, and all the content available on Google on respective blogs, right? And I've got no copyright over the content. I repeat, I have got no copyright over the content, right? So finally, 4 fundamental rules of pleading. So these are the important 4 fundamentals. Rules of pleadings are: pleading should not state facts, and it says pleading should state facts and not law, right? So as it says, the pleading should always state facts, not law, because the law point is going to be decided by the court. So court is going to decide what is going to be right as per the law, right? Because the party cannot become judge in his no one can be judge in his own cause. So it is the judge judge of the court, right? So the judge of the court is going to decide what is right after listening to both the parties, right? So as per the principles of natural justice, which says when after listening to both the parties, after looking at all the evidences, evidences that respective supporting documents, all the documents submitted by both the parties in order to support their claim. After going through all the documents, then the court will decide. The judge is going to decide. The judge sir is going to decide whether, right, I repeat, the judge sir is going to decide which party is right, right? So that's why it says pleading should state facts and not law, right? The fact stated in pleading should be material facts, so it should be material facts, right? Pleading should not state the evidence, right? It says it should not state the evidence, right? Because that will be produced in the court, and after just checking, after just going through all the evidences, then the court is going to decide whether the evidence is admissible, whether the evidence is admissible or not admissible, right? The facts in pleading should be stated in concise form, right? The facts in the pleading should be stated in a concise form, right? The main point to be considered before a party is allowed to amend his pleading are firstly, whether the amendment is necessary for the determination of real question in controversy. It says whether the amendment is necessary for the determination of the real question in controversy. And second, can the amendment be allowed without injustice to other side, right? Okay, so these are the important things which I've explained with the help of available material, right? So let us go through this once again. Amendment of pleading when refused. So what are the situations, right? What are the conditions, right? So these are at this point of time, right? So these are the conditions on which the pleading may be refused. So let us have a look at it. When the proposed amendment is unnecessary, right? So whatever amendment which the parties have proposed, that is not necessary, right? When the proposed amendment cause an injury to opposite party which cannot be compensated for by cost, right? It says when whatever amendments which have been proposed by the party, it is going to create an injury, it is going to cause an injury to the opposite party, and after that injury, it will not be possible to compensate with the help of money. So even the compensation is not going to help the opposite party, right? So that's why. So these are the points, right? And when the proposed amendment changes the nature of the case, it means the whole cause of action, by introducing after allowing that amendment, the whole cause of action is going to change, right? So the nature of the entire case will change. It will change from A to B, right? So the point of contention, the cause of action, right, the issue will change. So court will never allow any amendment on the basis of which new issue, and if new issue is coming into the suit, so obviously it will change the entire nature of the suit, right? So in order to avoid that, the court may not allow the amendment. When the application for amendment is not made in good faith, it says when the application and the amendment is not made in good faith, if that amendment is brought, so obviously it is going to create it is going to trouble the other party, right? When there has been an excessive delay in filing the amendment application, right? It means when there has been excessive delay, it means with due diligence, the plaintiff, either party could have brought that particular issue, that particular point into the notice of the court, right? So the court could have taken the cognizance of that fact. If you're bringing that particular point, that particular amendment, that particular issue in the suit after a long delay, so obviously it is going to create hardship to the other party. So that's why, and that at that point of time, the amendment may be refused, right? So these are the important points which we have discussed so far, right? So okay, as the last point, it says the pleading, right? So the facts in pleading should be stated in a concise form, right? The main points to be considered before a party, right? It says the main points to be considered before a party is allowed to amend his pleading are: firstly, whether the amendment is necessary for the determination of real question in controversy? And secondly, can the amendment be allowed without injustice to the other side, right? So with this, we have come to the end of this topic, right? Thank you very much.